Good morning,
Mr. Semenya.
Chairperson, Commissioners. We have Advocate Nsiza to help us today. I think he will be led by my learned colleague,
Yes.
Mr. Vani.
Mr. Vani.
As the chairperson pleases, Chairperson, we do have Advocate Dumisa Nsiza, SC, available to testify. He is ready to take the affirmation.
Thank you. Advocate Nsiza, are you going to take an oath or affirmation, sir?
Affirmation, Chair.
Do you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand, and you are so affirmed.
I so affirm,
Thank you.
Chair.
Mr. Vani.
Thank you, Chairperson. Advocate Nsiza, firstly, I want to thank you for making the time to be with us today, particularly given your current health challenges. And so on behalf of the families, we're very grateful that notwithstanding these challenges, you have assisted the families in putting up statements, and you've made yourself available to come to this commission, and for that we are very grateful.
Thanks.
We will try to keep your evidence in chief as short and concise as possible so that we don't detain you unduly. Before we commence, I'd like to draw your attention to various affidavits that you have made, and I would like you to confirm that these affidavits are yours and that the signatures appended under each one are your signatures. And we'll start with the affidavit that you made out before this commission. That's at item number 2 of the index. It's your affidavit dated the 3rd of November 2025, and it's at pages 9 to 10 of the record. Do you confirm that that is your affidavit and your signature?
If I may just look. What page is it on?
It's on page 9.
If you'll bear with me. Yes, it is.
Thank you. Then let's turn to the affidavit, which is item 1 of the index. And this is the affidavit that, it's a supporting affidavit that you made out on the 8th of November 2024 in the case of Kalite and others versus Government of the Republic of South Africa and others. It's at page 128. Do you confirm that that is your affidavit and your signature?
Yes, I do.
Thank you. Then let's turn to item number 3, and that is a supplementary affidavit that you made out before this Commission of Inquiry. It's dated the 14th of November 2025. It's at pages 11 to 17 of your bundle.
Pages 11 to?
Do you confirm that is your affidavit and your signature?
On my file, the affidavit, supplementary, it says supplementary statement.
Yes.
11 to 13.
Yes.
Yes, I confirm.
Thank you. And then finally, we've also attached a copy of a supporting affidavit that you made out on the 13th of May 2015. It's at item 11 of the index. This is a supporting affidavit in the matter of Nkadimeng versus National Director of Public Prosecution and others. It's at pages 141 to 147 of the record. Do you confirm that that supporting affidavit is your affidavit and your signature appears at the foot of it?
Though in my file, it starts at 141.
Yes, correct.
Yes, and goes to 147.
That's correct.
I confirm it.
Yes. That was the application that Tembi Nkadimeng, now Tembi Similani, brought against the NDPP to compel a decision in her sister's case, Nokutula Similani. Good. Now let's turn to you yourself, Advocate Nsiza. What is your current designation? What are you currently doing?
Well, it's always a difficult question to respond to. In South Africa, I'm a practicing advocate, such as there is by any practice, because I am also an appointee of the African Union, where I am one of the 11 judges of the African Court on Human and People's Rights. That court sits in Tanzania, Arusha, 4 seasons each year. The last session, which lasted a month this year, was in February. The next session is going to be this coming June. And then the next session will be in September. The other one will be towards the end of the year. So yes, it's permissible for me to hold those 2 positions. But
Thank you.
It's a strain.
And until recently, you were the group leader of the Sandton chapter of the Pan-African Bar Association of South Africa, PABASA.
Yes, I was.
Can we then turn to your professional career, and perhaps I can refer you to page 3. That's of your confirmatory affidavit in the application launched by the Kalata Group last year. So if you turn to page 3 of this record and you go to paragraph 3, just to remind yourself, because I see you've had a long and distinguished professional career, but perhaps you can give the court a sense of your career. If you find it easy, feel free to just simply read into the record the paragraphs under that heading.
Yes, I don't know about distinguished chair, but it has been a fairly long career. If I could read it, what is here, I have practiced for over 40 years as of today. I was admitted as an attorney in 1984, practicing in the Eastern Cape, mainly in what then was known as political cases, in human rights cases. I represented many political prisoners throughout the 1980s and early 1990s. Between 1993 and 1996, I taught law at the University of the Transkei, which is now called Walter Sisulu University. In the mid to late 1990s, I was a Truth and Reconciliation Commissioner, or TRC Commissioner, and was the head of the investigative unit of the TRC. I was called to the bar in 2000 and took silk in 2005. I've been an acting judge in 3 divisions of the High Court of South Africa, as well as in the Labour Court on several occasions. In 2004, I was appointed by the Secretary General of the United Nations as a member of the International Commission for Inquiry on Darfur, not this current one, which was established pursuant to a United Nations Security Council resolution passed under Chapter 7 of the United Nations Charter to investigate violations of international humanitarian law and human rights law in Darfur. In 2011, I was appointed by the Socio-Economic Rights Institute as lead counsel on behalf of the families of the 37 Marikana miners who were killed by the police. In 2017, the University of Fort Hare Council appointed me as Chancellor of the University of Fort Hare, which was renewed in 2022 for another 5 years. I'm a founder, it should read a founder member. I'm a founder member of the South African National Association of Democratic Lawyers, NADEL in short, and I served as its president. I also served as president of the South African Black Lawyers Association. I was a member of the Judicial Service Commission and a visiting professor of political science and law at the University of Connecticut in the United States. I'm a former chairperson of the Desmond Tutu Peace Trust, and I was a trustee of the Nelson Mandela Foundation. I was appointed as ombudsman by Cricket South Africa. I also serve as a council member of the University of Cape Town. I no longer serve, just to make a correction. I no longer serve, but as at that date that I was doing this affidavit, I was. Rhodes University also confirmed on me a Doctor of Law degree, LLD, honoris causa, in 2021. In 2021, I was appointed by the African Union Heads of State and Government Ordinary Summit as a judge of the African Court on Human and People's Rights.
And Advocate Tabisa, at least Advocate Nsiza, it occurs to me that there's one important omission from that list, probably because it was attached to an affidavit which made reference to your involvement with the Truth and Reconciliation Commission. It wasn't included. But for the record, can you describe your position and role at the TRC, the Truth and Reconciliation Commission?
Well, I was appointed as a member or a commissioner of the TRC by the President Mandela, I think in 1994, thereabouts. And when we gathered for the very first time in Cape Town, which was the seat in the Cape of the Truth and Reconciliation Commission, the commissioners gathered and elected me to be the commissioner in charge of the investigative unit of the Truth and Reconciliation Commission. And the election and therefore appointment was unanimous.
Thank you. And a bit later in your evidence in chief, we will return to your role at the TRC. Now, since the winding up of the TRC, it's well known that you have been assisting victims, survivors, and families to seek justice in cases where amnesty was refused or not applied for. But I understand that you actually have a very personal connection because a member of your own family suffered a gross human rights violation, namely Batandwa and Ndondo.
Yes.
Could you just give the Commission a very high-level and brief explanation as to what happened to Batandwa and Ndondo and your efforts to achieve justice since that fateful day?
Now, how high level is high level?
Well, we don't want to take up too much time, but this case has already been highlighted before this Commission, so I think it would be interesting to hear your perspective.
Yes.
Just a few minutes, please.
No, I will endeavor to say it in a few minutes, but I will seek to ensure that nobody is lost as to what I'm referring to. Unfortunately, this book, with the title Unfinished Business, South Africa, Apartheid and Truth, is a book that I authored with Terry Bell. And we have devoted an entire chapter to and we have appropriately, headed it, The Killing of Batandwa Ndondo. Now, the high level of it is that on the 24th of September, 1985, Batandwa Ndondo, whose mother and my mother are siblings, was at home in Kala, Kalanga district in the Eastern Cape. And the shortened version of the story is that he was called to a kumbi that was waiting outside. And we will never know what it was, but when he came out of the kumbi, it was to report to a friend of his who was inside our home to say, man, these guys say I must go with them. And he said, I would like you to keep a distance, but follow us. There's something I do not feel comfortable about what they have asked me to do. Cutting a long story short, as that kumbi, which was tinted, whose windows were tinted incidentally, as it was proceeding out of Kala town, it came to a dead stop because Batandwa Ndondo got out of the window, ran across the road, shouting, "These people are killing me, these people are killing me." And he went around a house that was along the road, or in the yard which he had run. And as he was running, he was shot. The pathologist, Dr. Bota, who gave an account of what his autopsy report was, recorded that Batandwa had been shot 8 times. And 7 of those bullets were whilst he was in a supine position. So as he was lying there, at the foot of the female, the mama, whose house it was that he had tried to circle, being chased by the Askaris, as well as Mr. Dandala, who was a security police from Mthatha. That mother exclaimed, "Whose child is this who was being killed like a dog?" And breathing his last, or almost his last, he said, I am from the Nsiza family. That's as far now. Now, the thing is, and what concerns me, we're talking about the 24th of September, 1985. All attempts that we made, and I say I made, and my brother made, to pursue justice in this case, fell on deaf ears. But from 1985 to last year, for the very first time, Mr. Dandala, who was the security policeman who had accompanied these askaris from Mthatha to my home, he appeared before the magistrate's court for the matter to be remanded to the High Court for trial. From 1985 to last year, there had been no prosecution. I believe that some of the people who had been involved in the killing, especially the Askari females, have all since died. That's Batandondon and my relationship with him.
Thank you. And just for the record, and this is what we've been able to uncover in our research, an inquest into Ndondo's death was held in 1987, and 4 people were implicated, including one Dandala. And in August of 1988, 3 persons applied for amnesty. It included Dandala, Mr. Shabalala, and Eugene de Kock. And de Kock and Shabalala were granted amnesty, but it was refused in respect of Dandala. Is that your recollection?
Yes, I remember that. I always tied the refusal to Dandala with a refusal of amnesty to the then, Transkei leader, Kaiser Matanzima.
Yes. And do you recall submitting a formal...
Sorry.
Apologies, Commissioner.
Do you have Mr. Dandala's first name? There are many Dandalas.
Yes, Commissioner, we do. His full name
is Lamont.
Is Ginisiko, Ginisiko, Lamont Dandala.
It's Ginisiko, Ginisiko.
Okay.
Yes.
Thanks for that correct spelling.
Thank you.
And then Advocate Nsabeza, do you recall in 2006 approaching the NPA to investigate Ndondo's murder?
Yes, several occasions. And I think the NPA at that time in Mthatha was headed by Advocate Van Zyl, who went thereafter to Cape Town to practice. But he was the person who was serving as the Attorney General in the Transkei at the time. And in spite of all the efforts that were made, including by me, and again, it is in this, the killing of Watanda chapter, nothing came of it.
And then you mentioned that in November of 2025, the Eastern Cape DPP, Barry Madola, made a decision to charge that former police officer, Dandala, with the 1985 murder of Ndondo, and he appeared in court in the same month. What do you account for this decades-long delay in pursuing this case when it appeared that it wasn't a particularly complex matter to take up?
I would really like to know what the answer would be to that question. Because, as I indicated, even as soon as it had happened, I had personally engaged the Attorney General, as it then was known, Van Zyl. And over the years, I kept on writing to the extent that it was possible. My brother, Professor Nsiza, also did the same, because he was at home on the day that Battalion was fetched from our home and was subsequently killed. But, I mean, from the 24th of September, 1985, to just recently, being pushed from pillar to post without being given an answer as to why none of the killers of Batando and Ndondo have been prosecuted has been quite a heavy burden to bear.
Can you give me page 98? Let's now turn back to the handover of the cases by the TRC to the NPA, and I understand that you played a role in the handover of the cases, and perhaps just to refresh your memory, if I can ask you to turn to page 98 of your bundle, you will see that there is an extract from the founding affidavit of Lekanyo Kalata, which is from the application that he and the 25 families brought in January last year. And in paragraphs 95 and 96 onwards, Mr. Kalata refers to an account in which certain lists were handed over to the NPA, and that you and Commissioner Yasmin Suka from October 1998 engaged in correspondence, and you had meetings with the then NDPP Bulelani and Guka, as well as then Advocate Vincent Saldana. Do you recall playing a role in the handover of the TRC cases to the NPA?
I certainly recall the central effects surrounding that. My memory is no longer as sharp as that of young people like Yasmin Suga, who still remembers it. But without being facetious, I remember that, you see, this is what happened at the end of 1996, after we had handed over the full report of the TRC. Yasmin Suka, who was in the Human Rights Violations Committee of the TRC, was appointed, or was recommended for appointment by all of us to go to the Amnesty Committee, which was going to determine the fate of all cases that could not have been finished when people had made applications for amnesty during the mandate period, 1990 up to 1998. So Yasmin was in the Amnesty Committee. And we must, if I may get permission to just indicate that the Amnesty Committee was the only quasi-judicial committee in the TRC when people apply for amnesty, we were not going to say to them, well, you know, the mandate period of the TRC is now over, thank you very much. People wanted to know whether or not they would be granted amnesty or not. And that's why there was therefore this extension of the period of the TRC. And that's how Yasmin, from the Human Rights Violations Committee, where she was vice chair to Archbishop Desmond Tutu, was transferred to the Amnesty Committee. And they did their work until they had finished all the cases. And all the cases, I think the completion date was either 2001 or 2003. And it was then that Jasmine said, look, we need to take our findings to the presidency. And that's how then we began meeting these officials, you know, but the purpose was to then say, look, there have been people who, there are 300 odd cases which need either prosecution or further investigation or both.
Thank you. Just a small correction. When you mentioned towards the end of 1996, I think you meant to say the end of 1998.
Yes, I'm sorry, yeah.
And just in relation to Yasmin Suka, who's also testified before this commission, it is correct that she maintained a role in the TRC post 1998 all the way through to the issuing of the final volume, I believe it was volume 6, in 2002. She didn't mention that she had been seconded or transferred to the Amnesty Committee, but she was retained by the TRC to liaise with the Amnesty Committee and then oversee the issuing of that final volume of the report.
That may be a more accurate, you know, statement of what happened. But what I wanted to emphasize is that when all of us left the TRC, because it had come to a mandated period of its existence in 1998, you know, Yasmin continued to be part of the TRC. And I recall that it was as a consequence of all of us commissioners agreeing that there needs to be one of us who's going to be working in close liaison with the Amnesty Committee. It is in that sense that I said she went and was part of the Amnesty Committee.
Yes. Then let's turn to the different attempts that you and the former TRC commissioners that you made in respect of a call for a commission of inquiry, and the detail of these different petitions and letters are set out in the Kalata affidavit from page 102. Firstly, can I ask, why was it that you and the former TRC commissioners decided in early 2019 to approach President Ramaphosa with the request that he establish a commission of inquiry into alleged interference in the TRC cases.
The question is?
So perhaps just to refresh your memory, you can turn to page 102 in your bundle.
Yes.
And there you'll see that in February 2019, 10 former commissioners of the TRC addressed a letter to the President calling upon him to appoint a commission of inquiry into the interference that undermined the TRC cases. And commissioners, that letter is actually attached to this bundle. It's at item 8, Commissioner's letter to the, no, it's not item 8. Sorry, it's item 7, former TRC Commissioner's letter to the President dated 5 February 2019. That's at page 121. So the question is, why in early 2019 did you and the other commissioners decide to approach the President with a request that he establish a commission of inquiry?
I think it had become clear to us that there was a lot of unfinished business. The TRC matters, there were still cases that had not been resolved, in the sense that it's either there had been no prosecutions, or there had been no further investigations. And to us as commissioners, even though it was so many years after the first session of the TRC had come to an end at the end of 1998, it was still our concern that our work was appearing to be just disappearing and was not going to be accounted for. I think there were ways in which we got together and we sought that there should be an intervention, and that intervention would be to do what we did, to approach the presidency for something to be done about what it was clear to us was the unfinished business of the Truth and Reconciliation Commission. Perhaps I need to say this. South Africa, at the commencement of the TRC, had adopted a stance, a position in which, even the defined gross violations of human rights, killings, abductions, torture, severe ill treatment, which were defined as gross violations of human rights. But the TRC, the Act, paraphrasing, said people would, even if they were found to have committed those crimes, however heinous the crimes were, they would be, they would be granted amnesty. There were certain provisions. One provision was that there should have been a full disclosure of all the facts relevant to the commission of the gross violations of human rights, in relation to which there was this application for amnesty. And the other, requirement was that it should be related to violations of human rights. So people are given a period during which they must make, applications for amnesty. And it was clear, the law was clear, that if the people didn't apply for amnesty when they knew they ought to have applied for amnesty. Or if having applied for amnesty, they came to the commission and gave the commissioners listening a tissue of lies, and therefore were refused amnesty. Then the law had to be applicable. Then people who had not been charged because they had either applied for amnesty or they had been granted amnesty or had not been granted amnesty, then they would be charged. So that is the background, and that is, as far as I recall, that was the reasoning for a time limit. Those who had not applied for amnesty within that period, or those who, who didn't have a basis for applying for amnesty and therefore were refused, they would then, that amnesty would not be available to them. So the period after the first handing in of the 5 volumes of the TRC up to 2001, 2003, was the period that after that period, 300 odd cases were found to be cases in relation to which amnesty, on whatever basis, could not be granted. And those were the cases in relation to which one expected that from that time, take for instance my cousin's case, if he had served, if it had been looked into, Batamnanondo's case. But there was nothing that happened between 2003, even in cases where there had been a clear indication. So the commissioners felt that, even the Archbishop felt that, this is something in relation to which the authorities must be approached, because it was casting a dark cloud on what the commission had done, and we felt that it was a disservice to the commission.
Yes. And of course, it wasn't just the Ndonda matter that had been visited with neglect. As I understand it, you were also supporting other families. And it's a matter of record before this commission that following the plea bargain that had been struck in the Chikani matter in 2007, there were no further inquests in respect to the TRC cases or prosecutions until 2016, when an indictment was issued in the Nokatula Simelane case. And you will recall that you signed a supporting affidavit in that matter. That's at item 11, pages 141 to 147, in which Thembi Simelane went to court to compel a decision out of the NPA in her sister's case. So that was a period of apparent inaction of about 9 years, nearly 10 years.
Yes.
What is your reaction to the fact that the family of Nokatula Simelane had to make a substantive application to court to force a decision out of the NPA in respect of her sister's case, which also dated back to the early 1980s?
Well, I mean, it was disconcerting, especially if one looks at the manner in which Simelane was abducted and severely tortured. it's unspeakable even to describe the way that she underwent the kinds of torture, that Nocturnal Simelane underwent. And it's not as though there were no efforts to indicate that the perpetrators ought to be followed and be prosecuted, that nothing of the nature happened. And for me, what is disconcerting is the fact that for some reasons, the delay was of a nature that caused the perpetrators either to escape being charged or they died, which would mean that the relatives of those who had been killed would not have seen or known justice. So it's been a matter of great disconcern. I mean, a matter of concern for me.
Yes. Well, at least that case did then open the door to some action because, as mentioned, the indictment was issued the following year in 2016, and then we saw the Timol inquest taking place in 2017, and then others followed. If we could return to February of 2019 when you and the other commissioners called upon the President to establish a commission of inquiry. Am I right in saying that you were in part prompted by developments in the Rodriguez case, which was happening around that time? And you'll recall in the Rodriguez case, he sought a permanent stay of prosecution because of the long delay. And it was in that matter, an affidavit was filed by the NPA in which the NPA admitted that it had been subject to political interference. Am I correct in saying that that development prompted you and the commissioners to seek a commission of inquiry?
Yes, indeed.
Yes. And can I get your comment on the approach of the NPA? In that matter, Advocate Turi Pretorius, he put up a supplementary affidavit in which he stated that, yes, the NPA had been subjected to interference in relation to those cases, but that blame should not be attributed to the NPA because they were the victims in that case. The blame should be attributed to the outside forces who imposed their will on the NPA. What's your response to that stance the NPA took?
Well, unfortunately, I disagree. I mean, the NPA, as at that time, had a duty to perform. And they could not, in my honest and respectful view, simply not do the work that they ought to have done to pursue prosecutions to the bitter end on the basis that Turi Pretorius was pushing.
Now, the judgment of the full court in the Rodriguez matter noted with concern the interference and called upon the NDPP to conduct an investigation or inquiry. And this was also endorsed by the Supreme Court of Appeal Am I right in saying that this ultimately led you to be appointed by the NDPP to conduct an inquiry which has become known as the Nsiza inquiry?
Well, when one looks back on things, one is able to say that in fact is so. Though I've got something to say about that appointment. It was a strange appointment as things are, because I was just given a brief to give an opinion as to what the measures are that the NPA should take in the further investigation or prosecution of TRC-related cases. No unit, no investigative unit, no, I mean, it was just a brief to Mr. Nsiza, nothing more. And it was after I had to and fro engaged the NPA on the brief that I had received. And I had said, the minimum that you can do without a structure to investigate things that ought to be investigated via the brief. At least I need the support of no less than 2 junior counsel who are going to do the heavy lifting, going backwards and forwards and making the kinds of inquiries that they ought to make. And that is why by the time I wrote what is called my report, it was with the able assistance that I got from the junior counsel, particularly Shaista Kasia. And we then wrote the report. And it was because of the difficulty that I had experienced in such a mammoth task as to establish what the NPA or the National Director of Public Prosecutions at that time had asked me to do, that in my recommendation, or in one of the recommendations I made, was that there must be a full-blown inquiry, and that inquiry must have these, search and seizure, this, that, and the next thing, and that the question of political interference must be investigated because it became a theme. Yes, we wanted to do this TRC related, this TRC. Ackerman was reported by my assistants to have told them, to have indicated that they were interfered with. Reciprocally, who I called to my inquiry, was, unequivocal in stating, that there was political interference. I didn't get the opportunity because of time to get input from Chris McAdam, for instance. But it was enough for me to write the report that I did. And especially, as I say, after Vusi, because he himself came to my so-called inquiry.
Thank you.
Mr. Nsiza, you also decry the fact that the terms of reference were too narrow. If you can perhaps say what else would you have wanted to see in the terms of reference?
Well, to the extent that, as I say, it was an investigation where I didn't have the machinery to do the investigation that I would have wanted to do. I would have loved the terms of reference to be specific about whether, having made the findings or when making the recommendations, I would also be directed to indicate what should be done for quick resolution of matters that have not, been resolved for decades of years.
Yes.
So that was for me outstanding.
Yes,
in
thank you.
terms of reference.
Thank you.
Thanks.
Thank you, Commissioner. Chairperson, I see it's almost 11 a.m.
Yes.
Would this be an appropriate time for the tea
Yes.
adjournment?
We'll adjourn and reconvene at 11:15.
As the Commission pleases.
Thank you, Mr. Vani.
Thank you, Chairperson. Advocate Nsiza, just before tea time, we were dealing with your inquiry. And perhaps just to wrap up that section of your evidence in chief, can I ask you to turn to page 5 of your bundle? And I'm going to ask you to read in the record paragraphs 15.4 through to 15.5.2. 15.4 is at the bottom of page 5.
Well, it starts at 15. We say, I specifically confirm that.
At 15.4,
15.4.
at bottom of page 5.
That in January 2023, I was appointed by the NPA to review the measures that had been adopted to deal with and prosecute TRC matters and to provide recommendations as needed.
And then you can continue on the next page down to 15.5.2.
I submitted my report to the NPA in June 2023, and it was released in February 2024. In this report, I found that the NPA and the PCLU were swayed from their constitutional and statutory duties in relation to the TRC cases. My inquiry could not investigate the political interference given the narrow ambit of its terms of reference and its lack of investigative powers.
On that, just before you continue, on that score about its lack of investigative powers and its narrow terms of reference, am I right in saying that your mandate only extended to looking into the NPA and not other institutions?
Yes.
And in relation to your lack of investigative powers, what was that like? Would it have been, for example, you had no power to subpoena in individuals or documents? You didn't have the power of search and seizure?
Yes.
So in that sense, you were saying that you were quite constrained?
Yes. As I think as I testified before the tea break, even getting the assistance, very able assistance of the two junior counsel who assisted me, was at my request, because I felt I couldn't just do this without, supportive assistance of the nature that I eventually then got from the advocates. But even so, I mean, let's say, for instance, somebody said, there was political interference. Here is the evidence. Who was going to chase that evidence in such a way that, when we make a finding to that effect, finding was backed by at least some evidence that was a product of investigations.
Thank you. Then in the light of that, could you read into the record your recommendations dealing with the alleged interference? So from 15.6 down to 15.6.3.
I recommended that, one, a commission of inquiry was the only sensible way to get to the bottom of why the TRC cases were neglected and suppressed. Two, a commission must investigate the extent and rationale behind the political interference and look into the roles of multiple state entities as well as implicated individuals. Three, it must be a public inquiry and be empowered to hold hearings and conduct a proper investigation, including the exercise of powers of subpoena and search and seizure.
Thank you. Now you stated 15.5 that you submitted your report to the NPA in June 2023 and it was only released in February 2024. So we're looking at a delay of around 7 or 8 months. Were you concerned at the long time it took to release your report publicly?
Yes, Madam Commissioner, I was, which is why I was at 6 and 7 at the end of having compiled my report as to whether I should publish it, but then I felt that that would not be the proper way to deal with it because I had been instructed by the NPA, and therefore my report would have to go back to them. But I kept on asking, when it was going to be made available to the public. So I was quite concerned about the fact that after I had given my opinion, there didn't seem to be any action that would be following the recommendations that I had made.
Now, you issued your report to the NPA in June of 2023, and you recommended that a commission of inquiry was the only sensible way forward in relation to the neglect visited upon the TRC cases. And yet, that did not appear to be taken forward because the families ultimately had to launch an application to the High Court early last year, 2025, in which part of the relief they sought was an order compelling the President to establish a commission of inquiry. And then, as we know, that matter was partially settled when the President agreed to establish a commission. What's your reaction to the fact that it appears that your recommendation was not taken forward in relation to a commission of inquiry, and that several of the families then had to launch a substantial application to court in order to get this commission?
And to be frank, my reaction was not dissimilar to the reaction that we as TRC commissioners had had. When, there clearly was a need for investigation of those cases in relation to which amnesty had not been granted. But there had been no steps that had been taken. Because we must understand that accountability was always part of what needs to be done about TRC-related cases. They can't just disappear, especially those cases 300 odd cases in relation to which amnesty had not been granted on whatever basis. My sense is that it would have been a travesty of justice for nothing to happen. So I had expected that there would be prosecutions and or further investigations as was required by the law. Accountability.
Thank you. Now, I want to turn to your supplementary affidavit. That's at page 11 of your bundle. And you will recall that towards the end of last year, you brought to the attention of the family's legal team an incident that took place while you were a TRC commissioner during the late 1990s. And you stated that you needed to bring this incident to the attention of the commissioners. It deals with your encounter with the late General Tini Groenewald and other former SADF officers. Now, I'm going to ask you, because I think it's quite important for the Commission to hear this, I'm going to ask you to read into the record paragraphs 5 to 16 of this supplementary statement. It's at page 11 of the bundle.
Yes.
Paragraph 5 is at the bottom of the page. Yeah.
Yes, I see that. I can still remember that day. Anyway, if I have not covered it in the way in which I still remember it in these pages, I will do so with the permission.
Yes, you're free to add anything you wish afterwards.
Perhaps let me presage reading this by saying it was a very strange request because, you know, the late chairman of the commission, Archbishop Desmond Tutu, and the late deputy chair of the commission, Alex Borain, they called me with Mr. Makatla and say, listen, we have received a call and there's been a request that those who are in the security services want to see and meet you. Because they have something to indicate to you. I didn't know whether Dr. Borain and the Archbishop knew exactly what it was beforehand. And I then, took Mr. Makatla with me, and we came to a place, Central Johannesburg. It was known then as the Joburg Sun, bluish, very prestigious hotel. And we were told to go to a particular floor, and we went there. And I think what I am indicating here is something that has lived with me as a matter of concern for quite some time. Because we were being confronted by particularly the late Tini Groenewald, Dr. Tini Groenewald, with digging too deep in our investigations which was against what had been agreed upon. That's how it came across to us. And then they told us that there had been an agreement that, the TRC would not dig as deep as we were, especially in the investigation of these violations of human rights. And the rest is covered in this affidavit, because we listened, and at the end of it, we simply said, okay, we have heard, but that, we do investigations at the behest of the Archbishop and the TRC Commission in its entirety, but that we do not have that kind of instruction. We are not aware that there were exceptions that we're supposed to make in our investigation of gross violations of human rights as defined by the Act. So yes.
Yes, I think with that overview, it would be useful for the Commission to hear the detail from paragraphs 5 to 16.
I wish to bring to the attention of the Commission a recent recollection I had regarding an interaction I had during or about 1996 or 1997 with former senior officers of the former South African Defence Force, SADF, including Major General Peter Hendrik Tini Groenewald. Groenewald was a Major General in the South African Defence Force and was head of military intelligence in the mid-1980s under President P.W. Botha. Groenewald had been involved in clandestine operations to assist the UNITA and Renamo rebels in Angola and Mozambique, and in South Africa in the mid-1980s. He spearheaded secret SADF support, including offensive paramilitary support for Mangosuthu Buthelez's Inkatha movement for purposes of promoting division and violent instability amongst black people. Groenewald was also a key figure in the early 1990s, quote, Committee of Generals, that opposed the political transition and supported the creation of an independent Afrikaner state. The Committee of Generals was formed around 1993, following the assassination of Chris Hani, with the goal of uniting right-wing groups. Other prominent members included General Constant van Lieuw, Lieutenant General Koos Bischoff, Lieutenant General Kobus Visser, and Lothar Neethling, ex-Deputy Commissioner of Police. Groenewald died on the 2nd of November 2015. Around 1996 or 1997, I was asked to attend a meeting with Groenewald and other former senior SADF officers at the Johannesburg Sun and Towers Hotel. I was accompanied by Lwandile Wilson Magadla, the head of the TRC's Special Investigative Unit. Magadla died in August 2011. I believe that this meeting has significant relevance for this commission. At this meeting, Groenewald and his colleagues urged me to cease investigations against the former apartheid security forces, since they had an agreement in place with the ANC that apartheid-era crimes would not be pursued. Around this time, the TRC had recovered a large number of SADF and military intelligence MI documents under a search and seizure warrant. I recall that Groenewald expressed shock at how rigorously the TRC was pursuing its mandate, given that there had been an agreement between the ANC, the National Party, and high-ranking officials of the SADF not to investigate those involved in past conflicts. He also said that they were in possession of dossiers which seriously compromised senior ANC officials. I informed Groenewald that in respect of my investigations of the TRC, I take instructions only from the chair of the TRC, Archbishop Tutu, and no one else. I recall that at some point after the meeting, Magadla and I reported to Tutu and Alex Burain, the deputy chair of the TRC. They advised us that we had adopted the right approach in our encounter with the generals. Nobody else was present in that meeting. Burain died in 2018 and Tutu died in 2021. At the time, I do not recall making a written recordal of this engagement or the contents thereof. I do, however, recall speaking on the issue with a Cape Town-based radio station, although I have not been able to find a recording of the interview. Some years later, in 2015, when I was interviewed by Stephen Grootes on Cape Talk or Radio 702, I made reference to this encounter. A transcribed copy of the relevant portion of this interview is annexed here to marked TBN 1. The remarks by Groenewald accord with what has since been alleged about an informal agreement not to pursue the TRC cases. In particular, it accords with a statement made by the F.W. de Klerk Foundation in July 2021, which confirmed that there existed, in quotes, an informal agreement between the ANC leadership and former operatives of the pre-1994 government, which ensured that, quote, the NPA suspended its prosecutions of apartheid-era crimes, in brackets, FW statement. The statement is annexed here to as DBN 2.
Thank you. And actually, let's turn to the statement of the F.W. de Klerk Foundation on page 16. And as you can see, the heading is titled "The NPA's Decision to Prosecute Apartheid-Era Crimes," the F.W. de Klerk Foundation editorial. And then just by way of background, we know that this statement was issued in July of 2021. Now, F.W. de Klerk himself died months later on the 11th of November 2021. So I think we can assume that he approved the issuing of the statement, or as it's called, an editorial. Now, this editorial makes reference to the Rodriguez case, which we have discussed, and statements that the NPA subsequently made, pointing out that it will proceed with prosecutions. And perhaps you can just read into the record the last paragraph on this page.
On page 16?
Page 16, the paragraph at the foot of the page.
Because of an informal agreement between the ANC leadership and former operatives of the pre-1994 government, the NPA suspended its prosecutions of apartheid-era crimes. However, in June 2019, in another matter affecting Rodriguez, the Gauteng High Court instructed the National Director of Public Prosecutions, Advocate Shamila Batoyi, to inquire whether improper influence had been brought to bear on the NPA in suspending apartheid-era prosecutions.
Thank you. So, Advocate Nsiza, now we have a situation where in the late 1990s you have this encounter with former senior SADF officers who indicate to you that there is an arrangement or agreement in place not to pursue these cases, and they take exception with your rigorous investigations. And then in 2021, we hear from effectively F.W. de Klerk through the F.W. de Klerk Foundation, saying that there was an informal agreement between the ANC leadership and the former operatives of the apartheid-era government to suspend its prosecutions of these cases. What is your reaction to that, and do you think it serves to explain why there has been so little progress in the TRC cases?
You know, I think the F.W. de Klerk statement puts it more succinctly than I ever could. It's not, it does not appear to me to be an inference that should be drawn from the events. It appears to me very clearly to be stating what the foundation and the ANC had agreed upon. No prosecution of apartheid-era crimes. And that's what triggered in me what Tine Groenewald had said to me and Tat Makal when we met them at the Joburg, as previously indicated. This is as explicit a statement as one could find of what a functionary of the de Klerk Foundation seems to confirm, namely of an agreement I mean the ANC, and whoever who was going to be speaking on behalf of the South African government of that time. So, if one was going to be speculating about what Tine Groenewald was meaning when he says, you know, you seem to be digging too deep, I'm not using exactly the words he used, then at least the subsequent statement, the one that I've been asked to read into the record, seems to be very clearly indicative of the existence of an agreement, you know, and unfortunately, we don't know the terms of that agreement. But there you are.
Thank you. Now, before this commission, there has been a narrative emerging from the government parties to this commission, I think without exception, that, and the narrative goes as follows: there was no interference or obstruction in the TRC cases, certainly not by the executive, and that the failure to proceed with most of the prosecutions can be attributable to the fault of individual prosecutors who failed to do their jobs. So I want to seek your response to that narrative in the light of the following. One, the instruction by the then Minister of Justice in 2004 to the then acting NDPP to suspend work on the TRC cases pending the issuing of guidelines. Two, when the guidelines or the amendments to the policy come out, they carve out a special dispensation for the TRC cases, and of course we're dealing with murder and kidnapping, those kinds of matters. And in that special dispensation, a number of criteria are put up to allow the NDPP or the MPA not to prosecute. And these criteria include things such as whether the suspect has been subject to indoctrination, whether a prosecution will contribute to nation building. Three, the approach of SAPS, NIA, and the DOJ to the work of the task team, in which they indicated that the NDPP had to wait for a recommendation from the Directors General Forum before he could make any decision in any TRC case. And finally, the fact that as we sit today, between 2003 and 2026, only 7 or 8 convictions have been secured in all that time. So in the light of that context, what is your response to the narrative that there was no undermining of these cases? It was simply the bad work of individual prosecutors?
Well, I suppose that is the reason that we have today the Khampepe Commission of Inquiry, which amongst other things is seeking to establish whether there was political interference. I mean, it's given why the TRC had been established, amongst other things, to bring closure to those families, like our family, to be satisfied that there has been, accountability. It's unacceptable that the only response that one gets for non-prosecution of cases that ought to have been prosecuted or further investigations of those cases to be placed now at the door of individual prosecutors. But we have it from somebody who was NDPP. Who explicitly stated that there had been political interference. And in this respect, I stated as having been said to me in the so-called Nsiza inquiry. Vusi did not mince his words, Vusi Pikoli, about political interference. If I never met Mark Adam and whoever else, but in Vusi did come and indicated. Now, I do not know to what extent and in what respect it could be said that executives who had said, as I later learned from reports made to me by those who were assisting me in the so-called SABC inquiry. Now, when they say we were politically interfered with, and that is why my recommendation was that this commission of inquiry, which has it's evolved from that, should establish the veracity of the political interference. So I have it from a person who was an NDPP and from other sources that they were interfered with. And I think it is the duty of this commission to establish on a balance whether it is established that there was political interference. To simply say individual prosecutors did not do their work is disingenuous, in my view.
Thank you. And just for the record, it's not just former NDPP Pikoli who reaches that conclusion. There is evidence before this commission which is carrying out the work that you have just outlined. Acting NDPP Silas Ramaita, SC, has also stated that certain conduct amounted to political interference. Acting NDPP Jiba is on record not disputing the evidence of former NDPP Pikoli. And of course we know from the Rodriguez case that the NPA admitted that it had been subject to interference. And indeed, former NDPP Shimela Batoy stated that up until the end of her term of office, as in January that was the position of the NPA, that it had been subject to interference in previous years. But in closing,
Chair, if I could, I'm sorry to interrupt. What is the question that was being posed there?
We are still getting there, Ms. Morocco.
thank you, Chairperson. So in the light of the statements of these former NDPPs and former acting NDPPs, what is your view to the claim that is being pursued, in particular by government parties to this commission, that the views of these individuals who were at the heart of the NPA should not be taken seriously?
I disagree.
Thank you. Then let's turn to some concluding remarks. Now, in your statement at page 6 of your bundle, I'm going to invite you, if you wish, by way of closing, to read into the record paragraph 16 to 23. And then if you so wish, you may add any closing words that you have. It's on page 6.
Thank you very much, Commissioners. I have frequently gone on record stating that there has been a shameful lack of political will to deal with the issue of accountability for the apartheid-era victims of gross human rights violations. I fully endorse Archbishop Desmond Tutu's statement made in 2013 that the failure to prosecute those who failed to apply for amnesty undermined those who did. The stories set out in Lucanio Talata's founding affidavit, as well as the supporting affidavits, are rooted in South Africa's bitter and divided past. They make for difficult and painful reading. We, as South Africans, entered into a constitutional compact that we would grant perpetrators an opportunity to speak the truth and earn full immunity from criminal prosecution and civil litigation. We made a solemn promise that those who were not amnestied or who spurned the process would face the consequences where their crimes were serious and evidence was available. Instead of cherishing the memories of those who died for our freedom and acting expeditiously to make good on our past promises, the post-apartheid state engaged in various machinations to ensure that the bulk of the TRC cases would never see the light of day. In so doing, they treated the families as second-class citizens, not worthy of equal treatment under our law. This must stand as one of the most shameful periods in South Africa's history. Most of the TRC cases cannot be revived. Suspects and witnesses have died. Truth, justice, and closure have forever been denied to the families, their communities, and the nation. In the few prosecutions and inquests that can proceed, they do so in a severely diminished way, since most persons of interest have passed on, particularly high-ranking offenders. The suppression of the TRC cases stands as a terrible stain on South Africa, on South Africa's post-apartheid history. It is, in my view, unforgivable. The families and communities are entitled under law and as a moral imperative to an independent commission of inquiry.
Thank you, Advocate Nsiza. You can stop there. Before we close, is there anything that you would wish to add?
Madam Commissioner and Commissioners, I will again recall the book that I indicated, which was entitled Unfinished Business, South Africa, Apartheid and Truth. And as early as 2001, when this soft copy was published, the late Terry Bell, the co-author with me on this book, published this book. 2001, this is what we say, and I quote, "The price of this unfinished business is, of course, once again paid by those who have already suffered horribly. Many relatives of the missing and the murdered, prominent among them, the Biko, Ribeiro, Ntlenge, Slovo, Skuon, Asphalt, and Madaka. And I can add now the families of the Kalatas of the Craddock Four. But in the book, we took it only up to Madaka. Those families are still seeking, if not justice, at least a greater approximation of the truth. There has been no closure for them. The United Nations declared apartheid as a crime against humanity. It was a system that robbed generations of people, not only of their dreams, but of their ability to dream. Apartheid was a complex system in which social engineers, architects, and planners set out deliberately to cripple educationally and emotionally the majority of the population. In pursuit of this goal, with a total and callous disregard for any human rights, they condemned millions of people to a slow death through malnutrition and preventable disease. To police this system, another section of the population was infused with the poison of racism. This was systematically done through formal schooling that deliberately manipulated history. It was aimed to, and to a wide extent, succeeded in providing the managerial and supervisory ranks on one hand and the fodder for the factories, mines, and farms on the other. Here lies some of the massive amount of unfinished business left by the TRC. It is not a healthy legacy. The process may have been aided by South Africa's transition to liberal democracy, but by not digging too deep, the TRC has in the long run bequeathed the poisoned chalice. Until this poisoned past is faced, there will be no real transformation. The TRC process went some of the way toward uncovering the truth, but it balked at exposing the horrifying extent of the apartheid system and bringing to book the most senior perpetrators of the human rights abuses it promoted, the politicians and the generals. The TRC deputy chairman, the late Alex Boren, claimed that there was neither the time nor the resources to sniff out informers. The truth is that there was no political will to do so. The time exists, the resources could be found, the guilty are still there, many still in possession of enormous power. This book, and this is in 2001, has shown that there is still a huge amount of evidence to be uncovered. Some of the documentation is also hoarded as a form of insurance or even blackmail by a number of apartheid criminals who escaped scot-free. The fact that these issues have not been faced has enabled the myth of a fairy tale transition in South Africa to be widely disseminated across the world. Yet, how long will this last? If the past is not dealt with, it will return to haunt us. Thank you, Mr. Commissioner.
Thank you, Advocate Nsiza. On behalf of the families and the Kalata Group, we want to thank you for your long service to South Africa and your unrelenting fight for justice. No further questions, Chairperson.
Thank you, Mr. Vani. Ms. Moroka.
Thank you, Chair. Good morning to Mr. Nsiza.
It's
Chair.
afternoon.
Oh, is it? Good. Indeed, Chair. We have no questions for clarification, but we do, Chair, reserve the right to apply to cross-examine Mr. Nsiza.
Thank you. Mr. Profi.
Thank you, Chair. Equally, no clarification questions.
Thank you. Ms. Ntambeleni.
Thank you, Chair. No clarification questions. Thank you.
Ms. Rukhoto.
Thank you, Chair. I also have no clarification questions for
Thank you. Mr. Siminya, is it you? Mr. Soni?
Thank you, Chairperson. We have no clarification questions from
Thank
the
you.
Commission side.
Mr. Vani?
Mr. Nsiza, at page 6 of your statement 5.5, you deal with, and it reads, I submitted my report to the NPA in June 2023, and it was released in February 2024. And then it goes on, you were asked, or you then remarked that you were tempted to release it. I was tempted to ask you, why didn't you? And it crossed my mind that something similar would have happened with some of the older generations. You remember Tiger by the Tail by Judge Mostert, the information scandal, that when I think it was President P.V. Botha who had not released the report, he did so. Didn't you think that that gave you some precedent? The other one I don't want to mention because the chairperson would fire me retrospectively if I refer to her report with DCJ Museneke in the Zimbabwe election debacle. But would you comment? The chair has not heard me.
I have to say on reflection, but also at the time I was, especially in light of the findings that I had made from the information that had been put before me by those who came to the so-called SABC inquiry. On the one hand, the brief had come to me from the NPA, and the NPA had not said when you return the brief and whatever report will be as a consequence of the brief we had given to you, you can then make it available to the media. So it seems to me that I was then bound by the fact that my principal, the person who had instructed me, was not expecting me in presenting to them my report, that I would make it available for publication. But I can indicate to you, Commissioner, that I then said, what is in this report is in the public interest. You need to make it public because it is exactly that, in the public interest. And the late Tikok was in the NPA also. I kept on saying to him, Mr. Tikok, that report needs to see the light of day. I can't claim credit for it having been published. But I knew that if it was not published for reasons that could not be made clear to me, I was going to do what I felt was in the public interest. It would never have been unpublished. That I was clear about. but I followed what I considered was protocol and the correct thing to do to your principal or to the person, to your client in the form of the NPA. I don't know if that answers your question, Commissioner.
Thank you very much. Thank you, Chair.
Thank you. Mr. Vani,
Chair, no further questions from my side.
thank you. Advocate Nzebeza, I must express our profound, profound gratitude for you having agreed to come and give evidence in person before this commission, given your health conditions. We truly appreciate it. For now, you are excused as a witness, but as you have heard, there might be a need for you to be recalled for cross-examination. We thank you, sir.
I'll still be alive, I can tell you. In spite of
You bet be.
Thank you.
Thank you, Madam Chair.
Thank you. Mr. Siminya, if I may get directions before we excuse the Advocate Nzebeza.
Chair, for the formal hearing.
Switch on the other mic as well, SC. Thank you.
For the formal hearings, there is nothing more for the day. And we know tomorrow is DS known again. We are back on Tuesday. If the matter can stand down until then or postponed until then, Chair.
Which matter should stand down?
The hearing.
I thought you meant Advocate Nzebeza's matter should stand down. When he has just been excused as a witness. What date is Tuesday?
5 May.
Fifth.
Yes.
Yes, thank you. These proceedings are adjourned until the 5th of May, 2026 at 10 hours. Thank you.